Should married woman need a husband's permission or an NOC to use her maiden name? Well, this case has been taken up by the Delhi High Court after a woman petitioner challenged the government rule on the use of a maiden surname by married women. The High Court has sought a response from the centre over this, and the matter has been listed next for May 28. Now, what exactly is the notification by the government? Well, the notification mandates women wanting to use their maiden surname to furnish a decree of divorce or a no objection certificate from their husband. The plea filed by the woman argued that the notification infringed upon her right to autonomy and privacy and reflected a gender bias. Well, the plea clearly stated that such a notification infringes upon one's freedom of expression and also violates fundamental rights.
See, it's very, very simple. It's basic Article 14 issue. Article 14 says of the Constitution that we have to be treated equally unless we are unequals. Unequals can't be treated equally. But here you're asking a woman to take a no objection. It's highly discriminatory towards a woman when you ask her to do that. There is no such obligation for a man. If he wants to change his name 50 times in life, he can do that. Nobody is asking him to take anybody's permission. So suppose tomorrow a man says, I don't like my name A and I want to change my name B, and he's married. I don't think so there is any notification which says, please ask your wife, does she like your name B? Because when she married you, you were name A. So why is this sort of a and forget, one point is discrimination towards a woman. And I think the language is also very discomforting of using NOC. And thirdly, you have to give your identification proof, which I can understand because it has to come in the Gazette. You have to give your quote unquote mobile number.
My colleague Rame is joining us on the phone line to give us more details. Rame, well, the High Court has in fact sought a response from the centre over the matter that has been listed now next for 28th of May. But it's quite surprising that such a notification by the government exists. The fact that a woman would require a husband's NOC or a decree of divorce just to use her maiden surname.
Absolutely. So the notice has been issued yesterday by the bench led by the acting Chief Justice of Delhi High Court. The Delhi High Court issued notice in the plea filed by a woman who was undergoing divorce. She challenged the stringent procedure outlined in the central government notification for a woman seeking a maiden surname. She must provide either a copy of the divorce decree or a no objection certificate from her husband, and that is what the notification said. The woman who was undergoing divorce proceeding wanted to change her name to the maiden name, and she was told that either she would require an NOC from her husband or she should also await the outcome of the trial proceedings to change her name. So she stated that infringes my fundamental rights. This is gender bias. If I have willfully adopted my husband's surname, why I can't go back? Why I cannot go back to my original surname, my parents' surname? If I'm undergoing divorce, I don't want to be called out by my husband's name, by my husband's surname. I want to be known by my own name. It's fine. When I was married, I used to happily have my husband's surname, but that is not the situation right now. So, stating all these facts, it has been challenged before Delhi High Court. Delhi High Court has issued notice, has sought the reply of Union of India, and the matter has been adjourned for May 28. We'll be keeping a close watch on this, what the affidavit filed by the Union of India says, and we'll be updating on this. Over to you.
Right. Right, Rame, I appreciate you giving us those details. And now let's leave it at that.